Our group in this firm here has handled intellectual property cases for years. In fact, the first commercial contingency case I worked on with John was back around 2001, and it involved the Backstreet Boys. And they were a musical group for you. Very, very big. People have no idea how big a business boy bands were and are. That case involved contracts, intellectual property, auditing record deals. It hit on several different cylinders. The defendant was probably the most famous Ponzi scheme operator in the history of the state of Florida, Lou Pearlman. He also did NSYNC, Britney Spears, and a variety of other groups. That particular case involved the intellectual property aspects of copyright, rights of publicity, merchandise, and then just the basic contract with the guys with the record label and auditing. So it took expertise in a variety of areas. Those cases went on for several years, and we resolved them very, very successfully against Lou Pearlman. We represented the Backstreet Boys against Lou Pearlman. I've had litigation with the manager of Britney Spears over her recording revenues, management deals. But these types of cases, the core of them is contract, but there's always intellectual property aspects. One of the most valuable things that they have are their publicity rights and how they exploit those. And they do it in a variety of ways: licensing deals, copyright in their music, use of their image and fragrances and products. So the potential revenue stream to exploit their persona and their intellectual property is significant. It is staggering how much the successful ones have brought in. We have brought those cases successfully. We have brought straight copyright cases successfully. I had a film case against Steven Spielberg, and we resolve that case before trial, still a confidential settlement agreement. That case was in the Southern District of New York. We've litigated some of these IP cases I've referenced in California. So even though we're based in Orlando, and we've got some other offices, but we can do these cases around the country. We've appeared in federal court in multiple jurisdictions. We tried the Harlem Globetrotters case in Phoenix, Arizona in federal court, the hottest courthouse in the country, by the way. But that particular case involved the publicity rights of iconic Harlem Globetrotters like Meadowlark Lemon, Curly Neal, and several others. The Globetrotters organization was not paying them for the use of their names, their likenesses, their player numbers on a big clothing line. It was very, very big some years ago, called FUBU. And they thought they could just do it. Many of the contracts signed with these old iconic players were signed in the 60s, before the Civil Rights Act. And they purported to have given away all of their publicity rights. The defendants took the position that they could exploit Meadowlark and Curly's names in perpetuity and not pay them a nickel in royalties, even though they hadn't dribbled a basketball in 30 years. Very interesting case. That case settled on the second day of trial, which is another illustration of how persistent we must be in these types of cases. To litigate that thing for years, and the defendants did not step up with a checkbook until we were actually in trial, picked the jury, started putting on evidence. So our clients were very happy, and that was another aspect of intellectual property, straight publicity rights.